My brother said it the way he said everything, with the slow certainty of a man who has never once had his version of events corrected. She has not held verifiable employment in 18 years, Chester told Judge Kenneth Avery, standing at the plaintiff's table with his lawyer on one side and a neatly stacked folder on the other. We have documented it. There is no record, no W-2, no tax filing consistent with claimed income, no employer on record. Nothing. He paused, just long enough for the words to settle into the wood-paneled walls of the Dunbar County probate court. Then he looked at me. Whatever she's been doing, it wasn't work. There was no jury. This was a bench hearing, just Judge Avery behind his elevated desk and the weight of 2 years of my brother's certainty pressing down on the air between us. My attorney, Simon Pratt, sat beside me without moving. On the table in front of him, beneath his legal pad and a thin manila folder, sat a sealed envelope. Standard letter size, heavier paper than you'd expect. In the upper left corner, a seal I had seen on buildings but never on paper addressed to a courtroom. I had not opened it, I didn't need to. My name is Harriet Colby. I was 42 years old that Tuesday morning, sitting in a courtroom in Pinewick, Georgia, while my brother tried to prove I had spent nearly 2 decades stealing from our dead father's trust. What Chester did not know, what his attorney, Alan Mott, did not know, what the town of Pinewick had not known for the better part of 18 years, was that the document in that envelope would change every calculation in the room before noon. The water in the paper cup tasted like old pipes. I noticed it because when the floor shifts beneath you, the mind grabs whatever it can reach. The hum of the HVAC system, the faint squeak of a chair somewhere down the hall. The way my brother's tie, navy with diagonal stripes, was slightly off-center. The way it always had been when he dressed for occasions that mattered to him. He had dressed carefully today. Horace Colby had built his plumbing supply business from a single truck and a rental space on the edge of town to a company that employed 31 people by the time he retired. He was not wealthy in the way wealth announces itself, but he was comfortable and careful, and he understood that what you build does not automatically survive you. 2 years before he died, he sat down with an estate attorney and created a family trust structured so that distributions to his children required evidence of gainful employment or documented public service. He never explained that condition to me directly. I didn't ask. I recognized it the moment his attorney read it aloud at the will reading, sitting in a quiet office in downtown Pinewick while Chester sat across from me with his hands folded and his jaw set. I recognized it because it sounded like my father. Our father had worked every day of his adult life, not because the work was beautiful, but because he believed that a person's function was visible and consistent. You got up, you did the thing, you came home, you did it again. He had no language for work that couldn't be seen, that required you to disappear in order to do it correctly. He had, I think, tried to understand. He simply ran out of time. Chester challenged my distributions 8 months after the funeral. He filed his petition quietly, through Mott's office, citing the trust's employment condition and his investigators finding that no standard records supported my claimed federal employment. The petition was clean, well organized, built entirely on absence. What Chester understood about me was limited to what he could see from Pinewick. What he thought he saw was a sister who had moved away at 24, who called sporadically, who visited just often enough to avoid being written off entirely, who offered vague answers about working for the government, and changed the subject with the practiced ease of someone who had been doing it a long time. He thought that practice meant I had something to hide. He was right about that part. I left Pinewick the summer after I graduated from Georgia Southern. I had applied to the Drug Enforcement Administration on a Tuesday in March, submitted my paperwork in April, and received my conditional offer in June. I told my parents I was taking a federal job in Atlanta. That was true for about 11 months. After that, it was never entirely true again. The DEA does not advertise its undercover program. The people inside it do not, as a general rule, explain it to their families. You learn early that the explanation creates more problems than the silence does. You learn to live in the gap between what you're doing and what you're allowed to say you're doing. My first assignment abroad came 14 months in. I spent 7 months in a city I cannot name, embedded in a network I cannot describe, doing work that would take a classified supplement to begin to explain. By the time I came home for my father's 65th birthday that October, I had learned to smile at the right moments, to eat whatever was put in front of me, and to answer the question, "What have you been up to?" with just enough texture to feel like an answer. Chester asked that question every time I visited. Same stuff, I'd tell him. Analysis work, interagency coordination, you know how it is. I really don't, he'd say, and there was something in his tone, not hostility exactly, more like the steady accumulation of unverified suspicion, that told me he had already decided what he believed. Chester had taken over our father's business at 30. He had married Pauline, who taught 4th grade at Pinwick Elementary and made the best peach cobbler anyone in the county had ever tasted. They had 2 kids, a mortgage on a house 4 blocks from the house we grew up in, and the kind of rootedness that makes absence look like a character flaw. He had not left, I had. In his accounting, that said everything. My mother, Irene, had understood things differently. Not because I told her more, I didn't, but because she had a way of watching you that meant she was measuring something beyond what she asked. She watched me the way you watch a weather pattern you can't quite predict. Not anxious, alert. Once, during a visit when my father was in the early stages of his treatment, and my mother and I were washing dishes while he slept, she said, without looking up from the sink, "You're somewhere else when you're home." What do you mean? I mean, part of you is always somewhere you can't tell me about. She handed me a bowl to dry. I'm not asking what it is, I just want to know if you're okay. I'm okay, I said. She nodded once, the kind of nod that meant she believed me and also meant she would not ask again. Then she said, "He's proud of you, you know. He just doesn't have the words for something he can't see." I didn't answer that. There wasn't an answer that would have fit in that kitchen. She died 14 months before my father. Ovarian cancer caught late moved fast. I flew back twice during treatment and was there at the end. I held her hand. She didn't ask about my work. She asked if I was sleeping. She asked near the end if I had found something worth staying for. Yes, I said. She smiled in the way people smile when they are satisfied that the right question got the right answer, and then she closed her eyes. I thought about that smile a lot in the 2 years after she was gone. The probate hearing had been set for 10 in the morning. Simon and I arrived at 9:45. He was thorough and unhurried in the way people are when they have already done the preparation and know what's in the room. We signed in, took our seats, and he placed his briefcase on the table with the same economy of motion he had brought to every meeting we'd had since I retained him 11 months ago. The authorization came through on Friday. He had told me the week before on the phone, his voice careful. The full confirmation. The administrator's office signed off. I understood what that meant. The sealed envelope in his briefcase contained a document that the Drug Enforcement Administration had spent 3 months deciding whether to produce. It had required a formal request, a security review, coordination between the DEA's legal counsel and the Department of Justice, and a determination that limited disclosure in this proceeding would not compromise ongoing operations. It had not been easy to obtain. That was partly the point. Chester arrived with Alan Mott at 10 past 10. Chester wore his navy tie. Mott had the organized, deliberate confidence of a man who has spent 30 years in estate disputes and believes documentation is the whole of any argument. He was not wrong, exactly. He had simply never encountered documentation he wasn't allowed to read. Judge Avery entered at 10:15. He was 61, silver-haired, with glasses on a chain and a posture that suggested he had given a lot of people information they did not want to receive, and had learned to deliver it with the same steadiness regardless. He took his seat, reviewed his notes, and said, "We're here on the petition of Chester Colby challenging the trust distributions received by Harriet Colby on the grounds of failure to meet the employment condition set forth in the Horace Colby Family Trust. Mr. Mott, you may proceed." Mott stood. He laid it out competently. The trust condition, my claimed federal employment, the investigator's findings. He had obtained records requests from 6 databases: IRS, Social Security, state employment, federal civilian personnel records available through standard FOIA channels. He had searched. He had found nothing. "We are not asserting fraud lightly," Mott said, turning briefly toward me before returning his attention to the judge. "We are asserting that the standard channels available to verify employment, channels this court can evaluate, return nothing. No W-2, no FERS pension contributions. No federal payroll record accessible through the Office of Personnel Management. The respondent claims federal service. The records do not support that claim." He placed his investigator's report on the bench. Judge Avery looked at it without opening it. Chester, across the aisle, sat with his hands flat on the table. He was watching the judge the way a man watches something he believes is about to confirm him. When Simon rose, he said 7 words first. The absence of a record is not the same as the absence of service. He let that sit. Then he walked slowly through the categories of federal employment not reflected in standard OPM files, positions that require compartmented clearance, roles that exist in parallel personnel systems, service that, by its nature, cannot appear in databases accessible by standard FOIA, because the appearance of that information would constitute a security breach. Mott stood. Your Honor, if we accept that argument, then any claim of employment becomes unverifiable and therefore unchallengeable. That cannot be the standard. Mr. Mott, Simon said, not looking at him, the standard is not what you can access. The standard is whether employment existed. Those are not the same question. Judge Avery's expression had not changed, but something behind his eyes had shifted. He was listening differently now. You're suggesting there is evidence that cannot be produced in standard form, he said. I'm suggesting there is evidence that required federal authorization to produce at all, Simon said. That authorization has now been obtained. When my turn came to speak, I took the stand and folded my hands on the rail in front of me. Mott was courteous. He had always been, even in the ugliest filings. Mrs. Colby, he said, you've heard the testimony about what our investigation found. I'll ask you plainly. Can you produce any documentation this court can examine that confirms your claimed federal employment during the period in question? Not in the form you've described, I said. He tilted his head slightly, and why not? Because the nature of my employment required clearance levels that aren't reflected in publicly accessible records. He let a small pause develop. So your position is that you worked, but the evidence of that work cannot be seen. My position, I said, is that your inability to access something through standard channels does not constitute evidence that it doesn't exist. Those are two separate claims. A sound from Chester's side of the room, not a word, more like breath released as decision. He stood. Not impulsively, deliberately. He had been waiting for this, not to add information, to anchor the proceeding in what he had already decided was true. Harriet. He said my name like a period at the end of a sentence he'd already finished. We grew up in the same house. I took care of Dad when he got sick. I ran the business when he couldn't. I was here. He looked at Judge Avery. She disappeared for almost 20 years, and now she's asking this court to take her word for it that she was doing something too secret to verify. That's not evidence. That's a story. Judge Avery looked at Chester with the patience of a man who has heard a great many people speak from emotion, and has learned that listening fully is usually faster than interrupting. Then he said, "Are you finished, Mr. Colby?" Chester sat down. Avery turned to Simon. "Mr. Pratt, you indicated you have something to submit." Simon nodded. He reached for his briefcase. He did not rush. That was the first thing I noticed, how completely unhurried he was, as if the pace of it was itself a form of precision. The clasps opened with a quiet double click. Inside, beneath the legal pad, was the envelope. Cream-colored paper heavier than standard stock. The federal seal on the face, blue and gold, centered and embossed. A narrow classification stripe along the left edge, the kind most people wouldn't recognize, and below that a return address block from the Office of the Administrator, Drug Enforcement Administration, Department of Justice, Washington, D.C. Simon carried it to the bench with both hands. Judge Avery accepted it. He held it for a moment without opening it, his eyes moving across the seal, the stripe, the return block. Then he looked up, and his gaze moved across the room the way a hand moves across a map, deliberately, looking for something specific. It passed over Mott, who was standing very still. It passed over Chester, who had leaned forward. Then it stopped on me, not on my face, lower. On the lapel of my jacket, where I wore, as I did every day I was off duty, a small brass pin. Plain, unremarkable, the kind that means nothing to most people. Judge Avery had seen that pin before. I could tell by the way his attention did not linger. It landed, confirmed something, and moved on. He broke the seal. The letter inside unfolded cleanly. He read it the way people read things that matter, top to bottom, then back to the top again slowly. The room held itself still. The HVAC hummed. Somewhere a door closed in the hallway with a soft, pressurized sound. He read for what felt like a very long time. Then he set the letter flat on the bench. He reached up, removed his glasses, and placed them beside the paper with the care of someone who wants every object in its correct position before he speaks. When he looked up, something had changed in the way he occupied the room. He was not simply presiding anymore, he was recognizing. "Mr. Pratt," he said, "has your client authorized the limited disclosure permitted under this document?" She has, Your Honor. He nodded once, then he turned his attention to the room. I am going to make a statement for the record, he said. Mott half rose. Your Honor, we would request. You will have an opportunity to respond, Mr. Mott. The judge's voice didn't rise, it narrowed. Not yet. Mott sat. Based on the contents of the document submitted under seal and the authorization provided by the relevant federal authority, this court recognizes that the respondent's employment record exists under restricted classification protocols not accessible through standard civilian or federal personnel channels. He paused. Let that land. The absence of documentation in the systems searched by the petitioner's investigator is not, in this instance, indicative of the absence of employment. It is consistent with the nature of the employment described in the verification provided. Chester's hands, flat on the table, did not move, but the stillness in them changed. It shifted from readiness into something else entirely. The document further confirms, Judge Avery continued, that the respondent has maintained continuous federal law enforcement service for a period of 18 years in a specialized capacity that required active security protocols preventing standard disclosure. The words were level. They did not need emphasis. They carried exactly the weight they needed to carry on their own. Mott's folder slipped. He caught it, but the motion had already happened. Chester turned and looked at me, and for the first time since we had sat down that morning, the certainty that had structured his face was gone. Not replaced by anything clean, just gone. Like a frame removed from a painting that turns out the painting wasn't what the frame implied. The petitioner's claim, Judge Avery said, rests on the assertion that the respondent failed to meet the employment condition set forth in the trust. That assertion has been directly contradicted by a federal verification document of the highest available authority in this matter. He folded his hands on the bench. Mr. Mott, does the petitioner wish to proceed? Silence, not long, absolute. Mott leaned toward Chester and said something under his breath. I watched Chester's face instead. The jaw, the eyes, the slight movement around his mouth where the old line should have been and wasn't. His lips moved once. Then he looked away from Mott and back at me. He looked at me for a long moment. Mott straightened. The petitioner withdraws the challenge, Your Honor. The petition is dismissed with prejudice. Judge Avery reached for his pen. Additionally, pursuant to Georgia probate code provisions regarding frivolous challenges, the court will assess fees and costs to the petitioner, including those associated with the federal verification process required by this action. He wrote, the amount is set at $19,400. Mott closed his folder. Chester did not move. Judge Avery set the pen down and addressed the room with measured finality. The petitioner brought this proceeding on the basis of what he could not find. He did not account for the possibility that what he could not find might exist beyond the reach of the tools he used. He paused. That is a limitation of method, Mr. Colby, not a discovery of truth. The hearing ended the way quiet things end, not with a sound, but with a stillness that means the terms have changed. Outside, the air was different. Still humid, still Georgia in October, still the same parking lot I had parked in countless times growing up when my father had county business. But something about it felt rearranged. Simon walked with me as far as the steps. The sanctions stand regardless of appeal. He could try, but there's nothing to challenge. The document was authenticated. The authorization was clean. I know, I said. He studied me for a second. You've been waiting a long time for that room. I've been doing my job, I said. The room was his idea. He accepted that and went back inside. Chester caught up to me at the bottom of the steps. He was alone. Pauline hadn't come, which I had noticed and said nothing about. He stopped a few feet away and didn't speak for a moment. 18 years, he finally said. It came out the way large numbers do when you've just learned they apply to something you misunderstood. You couldn't tell us. No. He looked at the ground, at the parking lot, at nothing specific, then back at me. I called you a liar in front of a judge. You called me a liar in front of the whole town for about 2 years before that, I said. The judge was actually an improvement. Something crossed his face that wasn't quite a smile. Wasn't quite the opposite either. I believed it, he said. I know you did. I don't know what I'm supposed to say. You don't have to say anything today, I said. Today just has to be what it is. He nodded once, the same nod our father used to give when he had run out of argument but wasn't ready to concede all the way. I left him standing there. Pinewick did what small towns do, it adjusted. Not dramatically, not all at once. The people who had been most certain began to be less present in the conversations where Chester's version of events had circulated. The story didn't need to be corrected out loud. It simply stopped being told, which in a town the size of ours amounts to the same thing. Chester paid the fees in 2 installments. He didn't contest the amount. 6 weeks after the hearing, he called. I was sitting in a rental car outside a field office in a city I can't name, and I almost didn't answer. I went back through everything, he said. Every time you came home, every conversation, I was looking for the lie. Did you find it? No, he said. I found a lot of moments where I wasn't asking the right questions. That was the most my brother had ever conceded in a single sentence. I gave him credit for it. There's a lot I still can't tell you, I said. I know that now, he said. We talked for 12 minutes. About our father, mostly. About the business. About small things. The kind of things that need to be said before the harder things can start to move. When the call ended, I sat in the parking lot a few minutes longer than I needed to. Relationships don't reset, they reconfigure. That's the slower and more honest version of repair, and it was the only one I had to offer. The following spring, I worked with the county library and the Pinewick Community Foundation to establish a scholarship. The Colby Irene Public Service Award, named for my mother, who had believed in quiet work, and my father, who had tried to understand it even when the vocabulary failed him. 2 years of tuition at any Georgia public university for a student from Dunbar County entering federal service, law enforcement, or international public health. The ceremony was small. Chester attended. He sat in the 3rd row. He didn't speak. He brought Pauline and she brought the peach cobbler, and someone found a table for it near the door, and people ate it without fanfare, which is the best thing that can happen to good food at a solemn occasion. I stood at the podium and said very little. I thanked the foundation. I said my mother would have approved. I said my father had understood more than he ever had the chance to say out loud, and I chose to believe that. My name on the plaque read simply Harriet Colby. No title, no years of service. There is a kind of quiet that comes when the version of you that other people needed you to be finally stops requiring your attention. It does not arrive loudly. It does not feel like winning. It feels like setting something down that you have been carrying so long you no longer notice the weight. Until the moment your hands were empty, and the air around them was lighter than it had been in years. My brother had built a story about a woman who disappeared and called it abandonment. He had filled 18 years of silence with the explanation that required the least from him, that I had chosen absence over family, invisibility over work, comfort over contribution. He had taken that story into a probate hearing and asked a judge to make it official. He hadn't counted on a sealed envelope from Washington, D.C. and a judge who recognized a federal classification stripe on site. Not every truth can be spoken at the time it's lived. Some truths wait in sealed envelopes until the room is ready to receive them. And when they finally open, they don't just change the argument. They change who gets to tell the story of what happened. That part I had waited a long time for.